When people think about estate planning, they think about planning for death. But the other side of that is actually planning for incapacity. So when we think about incapacity, it's where somebody doesn't have the mental ability to understand when they sign this document, this is what's going to happen as a result of it. Incapacity can happen if somebody maybe has dementia or Alzheimer's, maybe they had a stroke. So there's all these things that will then put somebody into an incapacitated state where they can no longer sign legal documents. In order to be able to help prevent this type of situation from happening, to ensure that their voice is known and what their wishes are, there are certain legal documents that you can have in place to ensure that everything is documented for you. These documents include an advanced healthcare directive, a power of attorney, and a trust. With all three of these documents, you can ensure that you have your agents identified on if something were to happen to you. These are the people that can make decisions for you and take actions, as well as what those decisions are that you want when it comes to healthcare and other asset related questions. So, a durable power of attorney is a document where you identify an agent to be able to make financial decisions on your behalf if you are unable to do so. If you didn't have the capacity to be able to act, this agent could essentially step into your shoes to be able to go to the post office, file tax returns, go to the bank, sell your home, do these things that if you couldn't do it because of some type of incapacitating event, they would be able to fulfill your wishes and be able to take care of you. An advanced healthcare directive, also known as a living will, is very similar to the power of attorney, but it is specific to healthcare decisions. In this document, you can identify an agent to be able to make healthcare decisions for you on your behalf if you were unable to do so. In addition to that, there's also certain end of life decisions that would be documented in your advanced healthcare directive. This includes things related to organ donations. Would you want to do any type of organ donation for transplant purposes, or would you not want to do any at all? It also allows you to state if you are in a persistent vegetative state, would you want to be taken off prolonged life support with extreme measures, or would you want to be kept on that prolonged life support? Another really important one is if you wanted to be cremated or buried. That is one that I know a lot of times people don't have that conversation with their loved ones, so it's important that it's documented. When it comes to trust and incapacity planning, your trust can have specific information that says if something were to happen to you and you were incapacitated, your successor trustee or executor would be able to step in, manage the assets of your trust to be able to help take care of you while you were incapacitated. This is so important, especially if you own a home and you have concern about being able to care for any type of medical expenses or having to put you in some type of assisted living facility. Your trustee at that point would then be able to sell your home or take the assets and be able to then move you into a home. The risks for not having estate planning documents in place when you are incapacitated are quite substantial. Without having the documents in place, then your family or friends would then have to petition the court for what we would call a conservatorship to be able to make medical decisions and healthcare decisions on your behalf. If you were to have estate planning documents in place, then you have everything documented. I had one client who called in and he said, my dad is incapacitated and he has dementia. We have to sell his home to be able to put him in an assisted living facility. And I said, okay, well, what documents do you have in place at this point for dad? And he said, the only thing that I have is his will. And I said, unfortunately, the will is not a document that actually works during incapacity. A will only comes into play when somebody passes away. So in that situation, they had this false sense of security that their estate plan was complete and that they were going to have all those protections by having that will. And this is the perfect example of not having a comprehensive estate plan, which would include an advanced healthcare directive, a power of attorney, and a trust to ensure that any type of situation that would occur, especially when it deals with incapacity, can be cared for by your loved ones. If a conservatorship is needed with the court, again, this is to be able to make financial or medical decisions on behalf of somebody that's incapacitated. You have to understand that this is a whole nother court proceeding, which means that there's going to be a lot of cost, can range anywhere from $6,000 to $10,000 for a conservatorship, and it's going to take time. Nothing with the court systems generally goes very quickly, so you have to expect that you may not have access to money or be able to do something quickly in this situation. If you have any questions on making sure that you have plans in place to plan for any type of incapacity, please give us a call here at Hermance Law. We are happy to help you.